Good afternoon and welcome along to the latest in our series of webinars. My name is Derek Granger. I'm one of the managers at PFP, and today I'm joined by Grant Summers from Grant Thornton. Grant, how are you doing?
Good, thank you. Good afternoon, everyone.
Good. So today's webinar is going to be on tribunals and how to avoid them. Before we kick into that, just some general stuff. I know that a lot of people who are listening in will be regular subscribers to our webinar and know that the kind of process. However, just for anybody who is listening in for the first time, if you want to ask any questions during the webinar, you can type them in and I will try and pick them up as and when we can. If we have any questions that we don't manage to get around to answering during the webinar, we will be doing a podcast right after this, and we'll try and get to them during that. For anybody who isn't familiar with PFP, just a quick plug, it'd be rude not to. We are one of the UK's leading providers of fee protection insurance, and we pride ourselves on the fact that we help our clients to grow their take-up rate significantly. So if there's anybody out there that thinks that they could benefit from that and that their clients could, then please feel free to get in touch with us. We'd love to speak to you. And with that, I will pass you over to Grant. Grant, just before we go through anything else, if you can just give people a little bit about your own background, that'd be great.
Yeah, my background is that I started my career at HMRC. I was 20 years as an inspector, dealing with investigations and going to tribunals. And then for 21 years, so I'm very old, we add that two together, I've been a partner at Grant Thornton, before that Deloitte. So all of my career, I've been involved in the full-time in the tax dispute arena. So I've won and lost cases, and I've learned from both, probably as much from losing as from winning. So what I'm going to do this afternoon is to talk through this presentation, cover these particular points, the HMRC inquiries, investigations, alternative dispute resolution, talk you through the HMRC review process, which has been with us for some while now, explain my understanding of how the tribunal actually works, and then remind everybody who's listening today that tribunals are now a public hearing. So for us as professionals, we need to be aware that the public can attend and that there will be a published decision where our conduct may well be mentioned. So moving on to the background and history. Some of the older members of this congregation, as it were, will remember the General and Special Commissioners. They were the predecessor of the current tribunal system. The General Commissioners were a fairly informal arrangement, and there were lots of them dotted around the country. So little market towns would have their own General Commissioners, and most of us tax practitioners were familiar with how the process went. Even in those days, though, any truly complex case, for example, tax residence or anything of that nature, would go direct to the specials, as would tax avoidance. So whilst many of us will have experience of the General Commissioners, not that many will have dealt with the technical cases. The specials tended to be pretty much legal and counsel being involved. But all of us will remember, probably with some fondness, the days of the General Commissioners. But in April 2009, which is quite a long time ago now, we got the first tier tax tribunal regime. And the first point there is that the first tier tax tribunal is very different to the old General Commissioners. What you need, first of all, is a decision before you can go forward with an appeal. So my first point in terms of the theme of this talk, as in tribunals and how to avoid them, well, the first thing is try and avoid getting a decision. What you need to do is, if you've got any good arguments for the client, if you've got any useful documents, get those to HMRC, get them fully explained before that decision is issued. Because once a decision is issued, it's, in my experience, quite difficult to have it overturned. So when we actually get to the tribunal, very different again, we now have a judge and one or two members to support the judge. The judge is very likely to be a tax barrister. He could be a full-time tax tribunal judge, in which case he'll certainly be a former tax barrister. To the point I made earlier about public hearings, there could be press interest. They're entitled to be there. The hearing will generally be heard in a magistrate's court or possibly an employment tribunal. So it has a formality about it. The client feels that they're in a proper court. HMRC, my experience is HMRC often crowd the room. So, you know, in the bigger cases, it's not uncommon that HMRC will have counsel, junior counsel, lawyers, assistant lawyers, and all the tax inspectors you can imagine. So sometimes you might get 10 or 11 people there, and the client just needs to be aware of that. So it's quite formal. If there's just you and your client, it's quite it can be quite overwhelming. It shouldn't put you off, but it's something to alert the client to before you turn up on the day. The decisions are published decisions, and I'll talk about more on that later. And there is an appeal process from the first tier tribunal to the upper tribunal. There need to be grounds for such an appeal. And if you appear before the first tier tax tribunal and the judge understands the technical points, which he will, if he says, I find these facts, and putting those facts to the technical question, I decide in this way, and it's against your client, you may find there isn't any automatic right to go to appeal to the upper tribunal. So that's something to be aware of. If you don't get the right facts found in your favour, then if the decision goes against you, you may be prohibited from going to the upper tribunal. And another small point to remember is if a client, and we do get the odd one, determined to have his day and go to tribunal, you just need to warn them. You might, and it's happened to me this, you might actually win at the first tier tribunal, and HMRC can appeal you to the upper tier tribunal. So again, very important that if you're going to win, you win with the right judgment, with all the facts laid out in your favour, so that HMRC will then not appeal you. They might well say later that it's a first tier tax tribunal and therefore it's not binding, but that's okay. If you've won, you'll be happy with that. Moving on to just mention HMRC inquiries and investigations. The point being that the first tier tax tribunal hears appeals against any HMRC decisions, and that could be the more usual technical aspect inquiries, to full investigations, Code of Practice 9, serious fraud investigations, contractual disclosure facility cases. Then moving on from just the tax elements to penalties. We're seeing quite a number of tribunal cases just about penalties. We're seeing things, for example, where HMRC are looking to charge a penalty for failed tax planning. And there's been a number of those cases going forward. Again, if you've got a claim that's you're unable to succeed with HMRC, then again, provided you've got a decision against the claim, you could take that to HMRC, to the first tier tribunal, or a notice. Could be an information notice, and again, you can go to the tribunal on that, and we've done that ourselves. On this point about inquiries and investigations, my experience is that in relation to tax evasion or tax avoidance, I would say the odds are stacked against you in terms of success at the first tier tribunal. Remembering that at the first tier, the onus of proof is on the appellant. So you've to make the case, you've to provide the documents, you've to provide the witnesses, and you're up against HMRC, who will probably be pretty well orchestrated in how they deal with the matter. My view in tax evasion cases would be that it would be better for you to negotiate the quantum away from the tribunal, i.e. with the inspector. You're asking the tribunal judge to do a lot if you've got a one-day hearing and you're talking about a 5 or 6 year tax investigation with 5 files. The judge doesn't want to get involved in the minutiae of the numbers. But generally speaking, tax tribunal judges, being, as I said, often tax barristers, are not really that helpful towards you when it comes to avoidance and evasion. Moving on to ADR. Some of you will be familiar with that. Some of you may be trained mediators. HMRC have trained up a number of mediators, and I know that some of the bigger accountancy firms and certainly lots of law firms have mediators trained up. The advantage that they are neutral and they can certainly help. You need to make an application to HMRC. I've seen the odd occasion where they've refused permission. It may be because they think they've already laid out their technical argument and ADR is not appropriate, but certainly it's an area that I would consider. And when would I consider it? Well, if you've got a breakdown in communications, if the facts are disputed and you can't bring any more to bear on that, and you need someone, if you like, independent to say, well, we can't get a perfect fact pattern. Can we do some kind of resolution? Can we, particularly if you've got 4 or 5 issues that are still in dispute? What you're hoping for at ADR is that we can agree one for you, one for me, and the three we can't agree, perhaps we can, negotiate those, or even if we're lucky, abandon them. Or indeed that there's a misunderstanding where I think that's possibly the same bullet point as breakdown of communications. You feel you've got a difficult tax inspector, you've tried your complaints route, and you think the only way forward is to get someone completely independent to come in and spend a day with both parties, with a view that often this is a long-running case that you can bang some heads together and reach a settlement. There are benefits for it in terms of time and costs, because it's cheaper than a tribunal. So back to and how to avoid them. Try and avoid them if you can. They're very expensive things, and we'll talk about that a little bit later. Certainly ADR can work. We've had some useful results. Bear in mind, for it to work well, I think there's still a lot of work that needs to be done to persuade the facilitator and probably an entrenched HMRC position. So you're going to need to at least bring forward some new arguments, or better articulate the arguments you have. And having done that work, you might be better, first of all, sitting down with your client and having some honest conversations with him as to how you see each independent point, and also to the HMRC investigator. I think ADR is useful in as much as it makes both sides sit up and think, well, what is the real strength of our case? What are the real undecided points between us? So generally I'm in favor of it. It's not as cheap as people imagine, because you've got to do a lot of work to make it work. Moving on to the HMRC review, which many of us will have become familiar with, and it's something I often hear complaints from when I'm talking to accountants around the country. First of all, you need an appealable decision. On this point, I think it's important to make sure HMRC have got all the taxpayer helpful facts before they issue it. Coming along with killer points later is not the best idea. Of course, sometimes we only see the decision when it comes to us as an outside referral or kind of a second opinion. There is a statutory right to have a review. So every time you have a written decision, you do have the right to ask for a review. There's no cost to having that review. It's an independent authorized HMRC officer. I say the word independent a little bit advisedly, because he's still a tax inspector after all, but it's not someone in the management chain. So in that sense, it can be helpful. He can either confirm the decision or he can overturn it. My experience, unless you send in some new or better presented facts or arguments, then it's highly likely that the decision will simply support the original decision. If the inspectors looked at both sides of the argument and sent you a decision citing his technical reasons for the tax he contends is due, unless you say something different, the review officer is very likely to read that as his starting point, and you may well get that decision. And that's certainly complaints I've had from colleagues and from my network out in the profession.
That's we're actually getting with a couple of questions coming in along those lines. What should you do when asking for a review? Which you kind of answered there, but yeah, that's the thing. It's got to be something different to what you've done.
I think for you need to sit back and say, well, what's the prospects of success with this review? And if it's just that maybe I haven't properly explained things, or maybe there's some element where I think we could get movement, we could reduce this bad bill to a not so bad bill, then you need to put forward those arguments. If you're going to the review officer with new information or a really new argument, it's highly likely that the officer will simply refer that to the caseworker for his comment. So if you've got that, you might be better going back to the caseworker.
Yeah.
Having a review doesn't stop you going to the tribunal, and it certainly doesn't, I think, alter your chances before the tribunal. You won't find the tribunal judge looking at the review officer's decision. He's got too much to do on the day or 2 days that he's hearing the case. Benefits in time and costs. Well, there is no more cost for you at all. It delays things if that's good. I'm personally not a fan of delay. I know some clients are putting off the hateful day. But my view overall on HMRC's reviews is if you don't have any further representations, you're not likely to be that successful. So then coming to how the tribunal itself works, Well, now that it's a new process, the old General Commissioners list and everybody working collectively and you phoning the local tax inspector, that's all gone now. You need to make the appeal yourself. You need to decide whether you're going to have a review, yes or no. If you've had the review and you're still going forward, or you've decided you want to go straight to tribunal, then you make your application online. You don't involve HMRC at all. I think an important point to remember here, the tax tribunal is not really interested in hearing complaints about HMRC. They're not really interested in the conduct of the case. They want a question brought for them to decide, and they want whatever facts and witnesses are needed for that. There is a well-known complaints procedure for HMRC. So my experience is the tribunal don't want to hear it, and you won't get far in trying to win your case by making those complaints and going into the who said what over the 5 years that it's taken to get to tribunal. Tribunal generally will just gloss over that. They're not really that interested. So the first tier tax tribunal then notifies HMRC that you've made an appeal. HMRC then decide what they're going to do with it. They've certainly got to give a stated case within a time frame, which will be directed by the first tier tax tribunal. The appeal might be run for HMRC by their regional appeals team. They've got these across the country. So you're up against someone who will have some expertise, certainly familiarity with the process, or the appeal could be run by HMRC's solicitor's office. That may well be the case if it's a tax avoidance case, or if the numbers are large, or if there might be any wider public interest in it. If it is run by a solicitor's office, then really we're into serious tax litigation here. It will be run as a litigation case, and the rules are different to the old General Commissioners. And it's highly likely that in that situation, HMRC will instruct counsel, often both leading and junior counsel. So it will be a more intense regime that you've put yourself in for. The tribunal itself will issue directions, and it's important to look at those directions. And you can go to the tribunal and ask for new directions and for directions to be changed. The usual one of wanting HMRC to be quicker is not really going to get you very far. But in terms of which witnesses should be called, you might want to do that. Failing to call a witness, or a witness just not turning up, you'll not get much sympathy from the tribunal. They'll say, well, you could have asked for directions, you could have asked for a witness summons. So this is a new regime from our old commissioners. You do need to follow those directions and get involved in them. Because bear in mind, it is your appeal, and the tribunal treat it that way. You are the appellant, so you have to run the case, as it were. HMRC are just responding. They're not leading it. The tribunal will direct what kind of appeal it will be, whether it's a paper one, so it's just done by exchange of correspondence, and a judge will deal with it. That might be an appeal against a £100 penalty, that kind of thing. Basic, standard, or complex. I've argued at directions as to whether I wanted a case standard or complex. In the scheme of it, it doesn't matter greatly. It might matter in relation to costs, but I'll talk about costs later in this presentation. There will be a formal hearing then if it's on the standard or complex route. You can choose the venue, and you'll be asked to suggest the duration of the hearing. When I say you can choose the venue, you can choose the city. Beyond that, the tribunal will decide which magistrate's court it's in. The duration of the hearing could be interesting. There's a lot that you need to do to prepare, and the more preparation you've done, the more smoothly the day will run. But typically, most hearings are 1 or 2 days. If you're looking for more than that, it must be a fairly big, complex case. And if you're asking the tribunal to go through 5 years of correspondence and come to some decisions, they won't want to know that. If there are a couple of basic questions, then they would expect that to be done in a day. I should have one more bullet point here, but it's not coming up. I've got a bullet point next, which is about the delay and timing. I'd just like to say something on that before we move on. It can take a long time to get a hearing, especially if HMRC involve their solicitor's office. The decision itself, which will be a written decision, The guidance to judges is that they publish that within 3 months, but I have had some cases that have taken up to a year to get the written decision out. A point to remember on that: you can't really influence that time period. If you think HMRC are dragging their heels, well, you can ask for directions, but they're bound to say they're busy, and litigation is litigation. You know, people aren't friendly towards you. But in terms of the publishing of the decision itself, even the tribunal are very reluctant to encourage judges to write an opinion, because it could look like people were trying to influence the judge. So you just have to grin and bear it and wait for the time it takes. But the remember point here is interest is running all the time. So if you're talking about a £500,000 tax problem, interest will be running on it from the year that is due to be assessed. If you lose, HMRC will demand full payment in 30 days, and you won't get a lot of sympathy if you've waited a year for the decision and then you say, well, I haven't got the money ready, because you knew there was a chance that you would have to pay this money. My experience is if they win, HMRC can be fairly determined, if not aggressive, about wanting their money quick. And on the interest point, a lot of clients of mine have said if they've lost at tribunal, well, it's taken 3 years to get there, or the whole inquiry's taken 5 years. Surely I won't have to pay all the interest. Surely HMRC will concede that the delay was on their part. I don't think you'll get far with that at all. Your only possibility is if there were unreasonable delays, lengthy unreasonable delays on the part of the revenue, which wouldn't be waiting for a legal process to come forward. You were aware of the interest, you chose not to pay the tax, then you were aware that interest was accruing. It's just a point to remind clients, because they're obviously upset they've lost at the tribunal. They're even more upset when you can't get a penny off the interest.
Yeah, I'd imagine that's quite an important point to be making, is just to make sure that the clients are prepared for the possibility that they may lose, and that there will be interest to be paying on that.
One other point on that, just another remember point. Some clients are used to litigation in their general business, and you'll often hear them say, you know, well, we'll get a good deal at the steps of the court. Now, you've got to think this is a tax tribunal. It's a different regime to normal litigation, normal kind of debt collection or business disputes. If HMRC have gone through their litigation settlement process, if they've written a decision and they've got to a tribunal, it's very difficult to get a settlement other than pay all the tax. And if it's with solicitor's office and they've instructed counsel, and you approach them 2 or 3 weeks before the tribunal and say, oh, my client's prepared to settle, what deal can we get? The deal is going to be pay the tax. That's my experience. Very little chance of changing it otherwise. So again, something to remind the client, and something to think, well, it may be worthwhile putting a bit of effort into this review or to this ADR process.
Yeah.
Oh, it did come up. Remembering that it's a public hearing, it will allow your client to have his day in court. You have to be aware there might be some other people in court just to enjoy the day too. I don't think there's any chance of anonymity. You'll hear that from a number of clients. I know of 1 or 2 who have tried, particularly very wealthy business clients of mine in London who haven't succeeded. The last one I remember way back was Bergkamp, a footballer at Arsenal. He managed to get anonymity, but I don't think you'd even get that now for a footballer. So clients do need to know that it's in public. My experience would be that I suggest if your clients make an appeal, they should appear. I strongly believe that. And if there's useful witness evidence they can give, then they should give evidence. They don't have to give evidence if they are the taxpayer, but my experience is judges expect them to, and it would probably help your case. And if your client wants his day in court, then he can have his day being cross-examined and you leading him so he can get out the things he needs to say. In a more technical appeal, for example, I did a capital allowances claim where the difference was whether we would get 100% first year allowance or writing down allowance, and it cost about £1 million for my client, so it was worth us going. In that case, I brought an expert, and that can be quite helpful. I've been successful 2 or 3 times in the tribunal on that basis. So if you've got a technical expert, it's highly unlikely that HMRC will have a technical expert. So the judge will get a lot, will give a lot of credibility to that person. So you may well want your client, and if there is a technical person, him as well. Reputational damage. Well, my point that there's no chance of anonymity. It is the case that the judge will comment in his judgment. He may comment actually during the presentation, but more likely in his judgment on the credibility and the honesty of any witnesses who appear and any professional advisors who appear. And it is a published decision, and it'll be in Taxation and Tax Journal, and someone will write an article about it. So again, that's just something for the client to think about when you're helping them with their witness statement. Chances of success. Well, my earlier comment, avoidance, evasion, HMRC are very keen to say that they think they win about 80% of them. I think the answer to that lies in the LSS, which you might all be familiar with. In 2007, HMRC announced their litigation settlement strategy, which said that they would litigate rather than do a deal in all cases where they had, in their view, more than a 50% chance of success. So if you're going to tribunal, they've obviously run the case through the LSS. So given that they, in effect, can choose how they go forward with cases, the odds are probably stacked in their favour. But I would say I think they're stacked in their favour in terms of avoidance evasion. I do hear anecdotally that tribunal judges are looking where they possibly can to help taxpayers. My experience is you've got much more chance of that if it's a technical point, where they can understand the technical point. You can probably express that, and your clients can probably give witness statements to that very well. And I think you would have a good opportunity there of winning it. My experience of anything to do with employment taxes, again, is not that strong. But anyone with experience of status and IR35 will know that it can go either way. In terms of representation and advocacy at the tribunal, there are three options. The taxpayer can actually take the case himself, and he really can have his day in court. If he does that without the proper bundle and all the supporting documents, then he really is going to struggle. There's no reason whatsoever why the taxpayer's agent can't represent him. The only point there, if you are contemplating that, is I think just two things. One, that I think best advice, given the formality that we've now got on the tax tribunals, is that the client ought to consider using counsel. He maybe ought to consider asking tax counsel to think about the merits of his case in the first place, and then whether he wants to use counsel to actually take the case for him, bearing in mind that HMRC may well use counsel. So at least you've covered that off. You've given them the opportunity, and then the issue for you as agent, if you are representing and being the advocate, is to remember that the tribunal will be judge-led, and it is quite formal. So in terms of presenting your bundle, presenting your witnesses, very difficult for you to be a witness. So if you're a one-man band and you're the one who's suffered this 5 years of investigation, quite hard for you to both be the advocate in that matter and be the witness. You may have to have someone else from your firm who's been part of the case if you feel that evidence is important to bring that in. And also in relation to that point, there'll be quite a lot of cross-examination from HMRC. So again, I think the client needs to have a decent witness statement that they can use as it were, a crutch to get them through that. Moving on.
I've got a question here, Grant, just pretty straightforward. Can you go to tribunal if HMRC simply refuses?
Refuses to issue a decision?
Saying, simply refuses, hang on, or even recognise that a complaint has been submitted.
Well, the complaints process is different. You need to pursue your complaints process through the channels which are published, and in the end, revenue adjudicator, etc. In terms of if you're not making progress, you can ask for a closure notice, and that will then give you either closure or a decision letter as to why they can't close. Yep. So, in terms of recent experiences, I've just actually been to the tribunal on a closure case. I had a decision published last week. So to make it sound better for myself, 2 weeks ago, I had a client acquitted in the criminal court. So we'll start with the good news. And then last week, my client, Krista Ackroyd, was a BBC newsreader, and she took her case, IR35, before the tax tribunal in Leeds for 3 days. I advocated that for her. And sadly, we got a decision against us last week. Now, the interesting point there is that because she was a newsreader, the BBC and ITV ran it that night last week, and all of the national press and the local press contacted me, and they all ran the story. We need to decide whether we appeal. We need to decide how quickly we can agree the tax with HMRC. But it's a stark reminder that that there are consequences from going to the tribunals. So tribunals, how to avoid them, then maybe we can avoid them. This lady, it came down to a simple question: does IR35 apply? I thought she had a very strong case, that she was a freelance in how she operated. And I thought HMRC took a quite simplistic view to it, that she was, if we like, almost an auto-cue cutie who was just reading the news, whereas she was much more than that. She was a very well-established journalist. But things like the fact she had a 7-year contract probably made the judge find the way he did. We're still looking at an appeal. Another case I've got at the moment where I'm waiting for a decision is a closure notice. That's in a tax evasion case. And some of you out there might have seen this. HMRC now are taking on corporate inquiries. And when they do it, it tends to be, if you like, an owner-managed business corporate. And what we see is that they open the inquiry and they inquire into VAT, employment taxes, corporation taxes, and they always seem to go on to the directors as well. This particular one, we've got a closure notice application because not only have they investigated the directors, but they've investigated the finance director, who's not a participant, he's not a shareholder, and his wife, who's got nothing to do with the business. So we've got a closure notice application for his wife saying, she's not involved in the business. Now, interesting there, we had a 2-day hearing up in Scotland, and we still had to do written submissions afterwards because HMRC couldn't deal with it in 2 days. And that was just for a closure notice for not the company, not a main board director, subsidiary employee's wife. And it still took us more than 2 days. That moves on to the document bundles. Again, the onus for preparing the document bundles rests with you as the appellant. When you talk to tribunal judges, it's one of their bugbears that people are turning up in front of them not prepared the way they want them to be. HMRC Sol's office respond pretty well, so it does make them look a bit more professional than we are, because they've got such resources to do that. You need to prepare them, and you need to tell the client what the costs of preparation are. My experience is it's very time consuming. You want to get all the documents in, but equally you need to think how, if you end up with every document under the sun, i.e. 10 bundles, how can you possibly use them all in a day? And you really need a core bundle, which you should be able to agree with the other side, so that both parties know what the real questions are. Some people mention contingent fees. Clients most often, because they're worried about the costs. Personally, I would never do a contingent fee in a tax evasion case. I think it's not correct to be doing that. But there are other cases where it could be appropriate. Clients are saying, look, particularly if it's one of my own clients, look, your firm have helped me with this planning, or they've said I could make this claim. You can put any skin in the game as well when we come before the tribunal. What can you do? So what I'm prepared to do, and I have done for a number of clients, is I want something up front. I know how much is involved in preparing for a case, so I want some kind of payment at least to cover my base costs. But then I'm happy to go contingent on the balance. I think that's not an unreasonable approach. In terms of costs themselves, if the case is listed as complex, then it's not usual for the parties to claim costs against each other in the first tier. You can actually opt out, but generally it's just not normal to claim costs. At the upper tier, costs could become involved. So again, if you lose at the first tier and the revenue appeal at the upper tier, you could be facing costs. If you then go from the upper tier, the next place is the Court of Appeal, and certainly there will be costs in the Court of Appeal. I did have a client where we went to the Court of Appeal and we won, and there was no problem with HMRC. We got all of our costs back, and that's just part of the litigation process. But generally, costs are not available at the first tier tax tribunal. So clients need to know that, even if they think their case is very strong and they want to, rub the inspector's nose in it. Well, it won't give them any money in doing that. Again, a point I think I've made it earlier in the presentation, but Tribunal Judge, who's a professional guy, very likely a barrister, he gets 1.5 days to write up for each full day of a hearing. So he's got a lot to do to write a judgment. His job is not to investigate all of the papers. So clients of mine have thought, well, the judge is a clever guy. He was listening intently. He'll go away and he'll go through all those points and he'll look at all those documents. He really won't. It's not his job to do that. If a document's important, if it's going to help the judge to make the decision, you really need to bring that to his attention. You really need to read in that document so that it's quite clear that both sides have seen the document. If HMRC want to say something about it, they get plenty of opportunity to do it. But just hoping, as the clients often do, that somehow this judge will find them all is really a bit naive. I presume we've got some questions on that.
Yes, we do.
But my sort of overriding point would be avoid tribunals by engaging with HMRC. If you're going for a review, bring in your new arguments straight away. If you're going for ADR, there's a lot more work involved, and it should prevent you going to a tribunal. And in terms of a tribunal, the old adage, if you fail to prepare, then you should be prepared to fail.
Excellent. We've got some questions here, and please feel free, if you have any questions that you'd like to ask, get them in now so that we can get through as many of them as possible. So I will kick off. The first one I've got here, if you've never been to a first tier tribunal, is there a way that you can get listings of what's in the court so that you can go along and view it and kind of get a better understanding of what happens in reality?
I'm not aware that you can apply direct to the tax tribunal for that. Local cases will be reported at the magistrate's court. Yep. So you can get their list.
Yeah, you can go along to those.
And that's probably available on Exhibit. Right. If you go on Exhibit, you can find out any that are on. Yeah.
Excellent. Hopefully that answers your question, Fiona. Got another question coming in, which was, do you have to inform the tribunal and HMRC in advance of bringing an expert along?
Yes, you would need to prepare your case and submit that in advance, and you need to submit witness statements from any witnesses that you're bringing, including an expert.
Yeah.
So you would need to say that, and if the expert's going to do a report, then you'd need to submit that within an agreed timescale. So that would be part of the directions process. So as part of the directions, both sides have to exchange their skeleton arguments, and both sides have to exchange witness statements. It can be the case that if you've got a witness statement and the opponent side don't challenge that witness statement within 30 days, then it can be taken as read. And I have been successful with that in the past. If HMRC don't respond, then you don't need to bring your expert or your witness because the statement has been read and accepted.
Excellent. Can HMRC charge late payment penalties if a case is lost at tribunal?
My experience has been that if they are contending penalties, then they will do that at the time of the decision letter, and the penalties themselves, if you can't agree them, will be the subject of the tribunal.
Excellent. Next question we have. HMRC are asking for personal information voluntarily, and they're threatening, they're demanding under Schedule 36 if not provided. It doesn't seem to justify this. Will HMRC back down if we say that we will see you at a tribunal? Well,
they haven't done in my case in Scotland, which is why I'm waiting for a decision. I think it's a really difficult area at the moment. I think some inspectors are taking up corporate cases and they're determined from day one to get at the director's personal side for the inquiry window that they're looking at. I don't think they should be doing it voluntarily. I think they should do it with a formal notice. But I don't know that there's any way of preventing it. My general view, whilst clients always don't like it, my general view is if you want to reach an early conclusion, the easiest approach is to actually get those documents from your client, examine them. If there's any decision to be made, make it, and if not, then submit them with your recommendation that it answers any questions that there were. In terms of how do you deal with that information notice, if it's been served, there's not a lot you can do. If they've gone along and got that ex parte from the tribunal judge, you're not entitled to be there. You can go for a closure notice, and as I say, we've got one at the moment where we're waiting for a decision. We had that just before Christmas and had until the end of January to do some submissions, which have gone in now. But it is a frustrating area for me and our firm. We're seeing more of them on the Grant Thornton kind of entrepreneurial client base.
Something we are seeing quite a lot of PFP as well. So I think it's across the UK that we're seeing that. Next question that we have: where do you access tax tribunal decisions?
On the tribunal website. Yeah. They're published on there.
Yeah, a lot of them tend to be in the national news as well.
I know. Yeah, well, yeah, but they. I have seen cases where HMRC, so the tribunal judge might submit to you as the appellant his written statement just for checking, they haven't got anybody's names wrong. He doesn't change the decision, and that gives you a kind of heads up. But the one that I had a week ago was actually published by the tribunal judge on a Saturday.
Right.
So my client had phone calls on Monday, and I had phone calls on Monday. But it was there seems to be no agreed protocol on that. It's published on the website, and then you can just print it off.
Excellent. And the last question we've got for now: who pays the cost of ADR?
It's a free process.
Yeah.
We've seen sometimes where they might ask for £300, and then the client pays his £300.
Yeah. Yeah.
But in the scheme of it, it's not something we're really worried about too much. We've had somewhere we've needed to pay £300 and the client had to pay it. But given the tax dispute is going to be an awful lot bigger than that, then I don't think that's a problem.
Someone saying their exhibit is only in England. Do you know where Scottish listings are?
I'm sorry, I'm Manchester based. I'm sorry about that. Oh no, I can't help you.
Fiona, we will try our best to find that out for you, and we'll get in touch after the webinar. So that's all the questions that we have at the moment. Just kind of before we close things off, in terms of how you're seeing things now compared to the kind of old commissioners kind of way of working, would you say it's better, Grant, or worse, or?
I think the changes came about because of self-assessment.
Yeah.
The old system, the general commissioners, was really there to combat delay, and making sure that people's appeals were brought before the commissioners and regularly refreshed, so that it was a driver to make people settle. I think if we're being honest about the new tribunal system and the revenue approach on the litigation settlement strategy, it hasn't helped, because there are a massive backlog of cases. There are thousands and thousands of avoidance cases.
Yeah.
I mean, we know of EBT cases going back a decade. We know of various planning things, gift aid going back more than a decade, and that can't be good. It can't be sensible to have thousands and thousands of cases of tax litigation all backed up. And the old regime wasn't kind of combated that.
Yeah.
I think there's probably less litigation. The old general commissioners making decisions month in and month out. That's gone. And I think having the new approach of a proper decision letter being raised, I think that's a valuable new insight. Before it was easy for the revenue just to say, well, I've raised an assessment to my best judgment and that's it, and then you didn't get very far. Whereas now I think there are some clear paths to resolution. And my only point about them is, whilst they're all there and they should all be used, they're only effective if you put the work in. And clients don't always want to hear that, because work costs time and time costs money, so you've got to bill for it.
And what would your kind of general point that you'd want to get across in terms of going to tax tribunals?
My view is it's a viable proposition, particularly on a technical point. If it is a technical point, it might well be worth, and we've done this a number of times, and the same would apply for ADR, that you ask HMRC to actually bring the technical specialist. So we often get that HMRC will issue you a letter, and you can sometimes see the font's different. They've just cut and paste the bit they got from the technical expert. Well, really, if they're standing behind that, and this could end up in litigation, then why don't you meet with a technical expert? I mean, it's not unreasonable, even if it means you've got to travel to where the technical expert is, because I know they're quite reluctant to travel these days. That's still an awful lot cheaper than going to a tax tribunal.
Yeah,
it really is.
So, yeah. So you see, kind of the best option is to try and avoid it.
I would say undoubtedly, yeah. Definitely in terms of tax evasion cases, I would certainly recommend it. It's not the best strategy. Similarly, complaining, and I'm not saying this because I was once a tax inspector. Complaining rarely, in my experience, resolves cases. Sure. It rarely does. It just causes a lot of anguish on both sides, and I think the client's expectation of what a complaint will do is often a bit unrealistic. They often think that HMRC will just go away, and that rarely is the result of it.
Yeah. And for those listening in today, obviously we have people from sole practitioners right up to some of the kind of largest accountancy firms in the UK listening in. But for those people listening in who maybe are smaller firms and have a client where there is they are going to go to tax tribunal, what would you advise in terms of kind of getting help from an advisor like yourself?
I think there would be a willingness on the parts of all of us to have a free consultation on that. Yeah. I mean, nobody's going to volunteer to read 5 years back correspondence, but the decision letter, certainly. I think you should think about asking other people within your firm or a trusted network of here's where I am. I've got the decision letter before I run off and make an appeal. Can I have a second opinion on it? I think that's really valuable. I think it's a sensible time to say to the client, look, I just think we need to spend a little bit of money here, a bit of time to get a second opinion before we headlong go down that route.
Yeah. Certainly I've had some examples of some clients where they kind of tried the best to help their client, and then after a period of time they've kind of went, oh, hang on a minute, maybe we need to get someone else involved, and would you say it's probably better to do that earlier than maybe kind of get part way down the road?
Yeah, I think so, and I think using the tribunals just as a way of resisting information notices and combating kind of issues between you and the inspector is not what it's for. Yeah. They are there to deal with, now that they're judge led, they are there to deal with tax technical questions, which may be about quantum, but generally are about tax technical, supported by documents. So they're not there for the old, where men of experience will tell you what your profits are.
Yeah.
That's not the place for them anymore.
Yeah. Got a good question here actually that's came in. Overall, who's benefited more from the tribunal, the taxpayer or HMRC?
It's a good question. I would say the taxpayer. But both parties have moved it into a regime that it has to move into in the modern world.
Yeah.
I think the fact that there are full-time tax tribunal judges, I think, having lost one last week, to be fair, I think you do get a fair hearing from them. I think they expect a high level of professional representation from us, but then why is that unreasonable? Yeah. I think it was a bit of a lottery under the general commissioners. I used to go 11 times a year to our local general commissioners as the inspector, and you did get quite a good relationship with the tribunal chairman, which probably went in your favour. If a certain appeal was listed as still not settled for 2 years, and then you dragged the taxpayer in front of you, he didn't start in a good place. Yeah. So I think overall, I think it's a better regime. It's a much more professional regime.
Yeah, excellent. Well, we're out of questions, but I would like to take the opportunity to thank you for coming along. Grant, it's been great, and I hope that those listening in have managed to get something out of that. Before we go, just to let everybody know, we will be sending out an email after this with copies of the slides for you to keep, and also with a link so that you could then go and listen again if there's any parts that you want to kind of revisit. And also, if you want to send them on to colleagues, you can do that. We were fortunate enough last year that Grant was one of our speakers at our conference, our UK Tax Investigations Conference, and we will be, of course, running that again this year. As of yet, we haven't confirmed our speakers, but I am sure that we will have a fantastic lineup, as we always do, and we look forward to seeing some of you there. The other thing is we will be doing a podcast after this. So for anybody that does want to listen to a podcast, you can get that by searching PFP online podcasts and subscribe to them. We're currently doing maybe 2 or 3 a month of those. So yeah, if you're into podcasts, it's a good thing to listen into. For myself, I'd just like to thank you for your time and wish you a good day for the rest of the day. Grant, I'll just pass it over to you to say goodbye.
Thank you very much, Neil. Very helpful. Thank you.
Excellent. Cheers, folks.